This week, the unthinkable happened within the hushed, solemn walls of a federal courtroom. This wasn't a scene from a political thriller or a theory circulating on social media. U.S. Marshals physically escorted and removed a sitting president of the United States from a judicial proceeding. To truly grasp the gravity of this moment, we have to look past the shouting protesters outside and the usual security alerts. This wasn't about Secret Service protection or routine logistics. If the presiding judge took this radical step, it was because she determined that Donald Trump's behavior toward a witness had crossed an absolute red line, a boundary that the judicial institution cannot allow to be breached under any circumstances. Before some dismiss this as mere media hype or get stuck on a sensational headline, I want you to look at the raw facts with me. Let's put aside the talking heads and the defense lawyers' spin. What matters here is the official court record. Throughout my career covering the legal beat, I have sat through hundreds of federal trials. I've seen defendants lose their temper. I've seen judges issue scathing warnings. But what I have almost never seen is a judge ordering federal law enforcement officers to physically remove a defendant in the middle of a testimony. This act tells us something fundamental. Something broke down irretrievably in that room. You don't get escorted to the exit because you rolled your eyes or sighed too loudly. The marshals intervene when your physical presence becomes a direct threat to the integrity of the trial itself. So, what actually happened? What words, what gestures pushed this federal judge, a figure appointed for life, meant to be above partisan bickering, to decide that the trial could no longer proceed safely with Donald Trump in the room? To understand, we have to look at the exact timeline, because precision is our only compass in this storm. The hearing began like any other federal session. Lawyers in their places, the defendant at his table, and an attentive jury. Then a key witness was called to the stand. According to those present, this witness was delivering a testimony that directly contradicted Trump's public narrative. At that precise moment, the disruption began. Initially, there were audible comments coming from the defense table. The judge reacted immediately with a verbal warning, a standard procedure to remind everyone that courtroom decorum applies to all, without exception. But the interruptions did not stop. The judge then called the lawyers for a private sidebar, giving a direct order: control your client, or there will be consequences. Yet the moment the witness resumed speaking, the record indicates that Trump turned toward the witness stand and directed a specific phrase at the individual testifying. Sources vary on the exact wording, but the consensus among observers is unanimous. It was a direct confrontation intended to intimidate and destabilize the person on the stand. The judge's reaction was instantaneous. She halted the proceedings and officially ruled that the defendant's behavior constituted witness intimidation in open court. It was then that she uttered the words that will be studied in law schools for decades. Marshals, please remove the defendant from my courtroom. In less than 60 seconds, Trump was being led to the exit, while the witness remained on the stand and the machinery of justice resumed its course in a heavy, stifling silence. If this were an isolated incident, we could call it a momentary lapse in judgment. But when we analyze the trajectory of the last few years, a systemic pattern emerges. We remember May 2024 in New York, where Judge Merchan was already threatening Trump with removal for repeated gag order violations. We remember August 2023, when Judge Chutkan had to intervene to protect witnesses from inflammatory public statements. And finally, the testimony of Jack Smith under oath, denouncing the deliberate endangerment of judicial personnel. 3 different judges, 3 separate jurisdictions, but one consistent behavior: a frontal assault on the process whenever the evidence becomes overwhelming. In law, we often call this consciousness of guilt. A person who respects the truth doesn't need to bully those who carry it. What happened this week wasn't a political act. It was the strict application of a rule that protects our civilization. No one, not even a president, is allowed to turn a court of law into an arena of threats. To understand why the expulsion of a former president is a tectonic shift in the American legal landscape, we have to look beyond the immediate shock of the marshals stepping in. We need to analyze the legal doctrine of courtroom decorum and why it is the thin line between a civilized society and total chaos. When a judge removes a defendant, they aren't just managing a person, they are defending the very concept of the rule of law. In the United States, the Sixth Amendment guarantees a defendant the right to be present at their own trial. It is a sacred pillar of our justice system. However, the Supreme Court ruled decades ago, in cases like Illinois versus Allen, that this right is not absolute. If a defendant is so disorderly, disruptive, and disrespectful that the trial cannot be conducted with dignity, they forfeit that right. By removing Donald Trump, the court sent a message that his status as a former commander-in-chief does not grant him a disruption license that ordinary citizens don't possess. This brings us to the core of the strategy we are witnessing. For months, legal analysts have debated whether Trump's behavior in court is a lack of self-control or a calculated tactical maneuver. If you look at the mechanics of this week's incident, it appears to be the latter. By forcing an expulsion, the defense creates a narrative of victimization. They want the public to see a rogue judge and armed agents removing a political leader rather than a judge simply enforcing the rules of evidence and conduct. But here is the danger in that gambit. The jury is watching. Every time a defendant undermines the judge, they risk alienating the very 12 people who hold their fate in their hands. Jurors generally crave order. They want to feel that the process is fair and serious. When the atmosphere turns into a circus, the jury's trust in the defendant begins to erode. They stop seeing a leader and start seeing a liability. Furthermore, we must address the specific legal fallout of being removed for witness intimidation. In a federal trial, tampering with a witness is not just a procedural hiccup, it is a separate felony. By acting out in front of the judge, Trump has potentially handed the prosecution a new set of charges, or, at the very least, a powerful argument for obstruction of justice. Think about the precedent this sets for future high-profile cases. If the court had allowed the comments to slide, every future defendant, from mob bosses to white-collar criminals, could point to this trial and say, if he can talk back to the witness, so can I. The judge knew that the eyes of the world were on her, and that to blink in that moment would be to surrender the authority of the entire federal judiciary. We also have to consider the psychological impact on the witnesses themselves. Testifying against a former president is already an act of immense pressure. The power dynamic is inherently skewed. When a defendant uses their physical presence or their voice to interrupt a testimony, they are attempting to reclaim the room. They are trying to remind the witness and the world who is really in charge. By ordering the marshals to act, the judge effectively reestablished the hierarchy of the courtroom. She reminded everyone present that in that square room, the black robe is the only power that matters. The removal wasn't just about stopping the noise. It was about protecting the psychological space necessary for a witness to tell the truth without fear. Finally, let's look at the broader institutional damage. The American legal system relies on a certain level of performative respect. We call the judge Your Honor. We stand when they enter, and we follow the rules of cross-examination. This isn't just for show. It's a ritual that prevents the search for truth from devolving into a street fight. When a figure of Trump's stature systematically mocks these rituals, he is attacking the foundation of the house he once led. The expulsion this week was a desperate, necessary attempt to shore up those foundations. It was the system's immune response to a virus of disorder. As we move into the next phase of this trial, the question is no longer just about the evidence or the testimony. The question is whether the American courtroom can survive a defendant who refuses to acknowledge its existence. We are no longer just watching a trial about specific crimes. We are watching a trial about whether the law itself still has the power to command respect. As we move into this final phase, we have to confront the most uncomfortable question of all. What happens when the courtroom walls can no longer contain the conflict? The expulsion we witnessed isn't just a procedural footnote. It is a signal that we have entered a post-decorum era of American law. For over 2 centuries, the unspoken agreement in our society was that while we may disagree on politics, we bow to the finality of the court. We accept the referee's whistle. But what we saw this week was a deliberate attempt to break the whistle itself. By forcing the hand of the U.S. Marshals, the defense has successfully moved the trial from the realm of legal facts into the realm of political martyrdom. This is the scorched earth policy of litigation, where the goal is no longer to win an acquittal based on evidence, but to delegitimize the entire institution so that any eventual verdict is seen as fruit of a poisonous tree by half the country. This strategy carries a terrifying price for the future of the American Republic. When the public sees a former president being physically removed from a hearing, the image bypasses the rational brain and goes straight to the gut. For his supporters, it is proof of a deep state conspiracy. For his detractors, it is proof of a long overdue accountability. But for the law, it is a tragedy. It means that the courtroom is no longer a neutral sanctuary for truth, but has become just another battleground in a cold civil war. If we reach a point where a judge cannot maintain order without the use of force against a political leader, we are teetering on the edge of a systemic collapse. We have to ask ourselves, if the highest leaders in the land do not respect the gavel, why should the average citizen? This erosion of respect filters down through every level of society, from local school boards to city councils, creating a culture where volume and intimidation replace debate and evidence. Furthermore, we must look at the long-term implications for the presidency as an office. Every action taken in this trial sets a binding precedent for how future presidents will be treated and how they will behave. By pushing the judiciary to this extreme, Trump has essentially redefined the boundaries of executive privilege to include the right to disrupt. If this behavior is normalized, or if it is successfully used to trigger a mistrial, it provides a blueprint for any future leader who finds themselves in legal jeopardy. They will know that they don't need a better legal argument. They just need to be more disruptive than the system's capacity to restrain them. It creates a perverse incentive where the most unruly defendant becomes the most powerful, effectively holding the judicial process hostage through the threat of chaos. The judges in these cases, Chutkan, Merchan, and the others, are essentially standing on a lonely island. They are trying to apply 18th century rules of conduct to a 21st century media storm. They are using a gavel against a megaphone. This week's expulsion was the judiciary's way of saying the megaphone stops at the door. But the reality is that the door is becoming increasingly porous. With every social media post sent during a recess, with every televised press conference on the courthouse steps, the trial is being tried in the court of public opinion simultaneously with the court of law. The danger is that the public verdict will be rendered long before the jury even begins to deliberate. When the defendant is removed from the room, he loses his voice in the trial, but he gains a massive, amplified voice in the street. In conclusion, as we watch the fallout from this unprecedented week, we must remain focused on the preservation of the institution itself. The specific charges, the specific witnesses, and even the specific defendant are, in the long run, less important than the survival of the principle that no man is above the law. If the court allows itself to be bullied into submission, the law dies. If the court is forced to use too much force to maintain order, it risks looking tyrannical. It is a delicate, almost impossible balance to strike, but what we saw this week was the system choosing to fight back. It was a reminder that while power may reside in the White House or the Capitol, the ultimate authority in a democracy must reside in the quiet, orderly, and respectful search for the truth. If we lose that, we lose everything. The Marshals didn't just escort a man out of a room, they were trying to escort chaos out of our civilization. Whether they succeeded remains to be seen, but the line has been drawn in the sand, and there is no turning back now.